And today we're going to be talking about something really cool that nobody really talks about or knows about, and that's title, how to hold title and avoid huge mistakes that could cost you a lot of money. I was talking to our host today, Miranda Frank. She's an attorney. I'll let her give a proper introduction in a bit. But I was sharing a story about one of my friends from elementary. She reached out to me not too long ago, and she, in an email, just saying, "Hey, look it, my mom's, passing away. I want to transfer title to my name, and I had some questions, but I got a meeting today to do it." And it was like super last minute. Long story short, it was an investment property that her mom bought back in the 1990s, in the early 90s. And since then, a ton of equity had jumped up and had risen. The values had just risen by a lot. Long story short, she transferred the title from her mom's name to her name, and Miranda could get into the details on that. But in my estimate, it cost her or them, the estate, somewhere in the six figures as far as taxes, because they just, didn't do it the right way, the more efficient way that, they would have saved all that money in taxes if they would have called someone like Miranda. And unfortunately, a lot of buyers out there, when they buy their home, they own it under their name, and it might not be the most beneficial way to own the real estate, but no one ever talks to them about it. And if they do hear about it during the escrow period, when it's literally like a one-page form that they fill out during escrow, and that's probably the only time that they ever even talk about it or think about it, and then they just forget about it. They might say, "Oh, I'll do it later. I might put it under the name I'm supposed to later." So that's why we're having this workshop today, is to avoid mistakes like that. Miranda, welcome. Thanks for joining us. Give us a introduction, please. Tell us about yourself a bit.
Okay. I'm an attorney here in San Diego. My office is actually in Spring Valley. I was downtown when I met Voltaire. But my clients come from all over, so north, south, east, west, wherever. I handle estate planning, and I also handle administration of estates. And we also handle litigation when things don't go as planned. My favorite thing to do is the estate planning and educate people. And that's why when Voltaire asked me to speak, I said, that's fine. That's what I do for a living. I talk, so I have no problem. But yeah, when he told me that horror story, I told him I have a lot of other horror stories. And it's important that people understand, what the options are for holding title, and what some of the preferred methods are. And that's what we'll talk about today.
Yeah, and in your estimate, Miranda, what percentage of property owners are holding title in like a less desirable way or something that doesn't benefit them? What percentage out of 100%?
You know what, honestly, if I had that knowledge at my fingertips, that'd be great. But I would say probably over half. Some people put their kids on title, and that leads to problems. And sometimes they own it as separate property when it's really community property. Yeah, there's a lot of people that could be taking a look at title.
Yeah, for sure.
Well, that's my dog. She's very needy. So if she starts making noise, I apologize. I haven't pet her for about 10 minutes. So
it's all right. All right, cool. So I know you have something to share with us. So if you want to share your screen and kind of just walk us through what you got for us tonight.
Okay, let me see if I can do this.
Cool. And I asked Miranda today also to share some real life horror stories about how title could affect everyone here. Okay.
I don't know. Can you see that?
We could see it. Yeah, we could see it.
I'm still, even though we've been doing this for, I don't know, almost a year, I'm still, I do like in person, and I'm so happy I got my first shot the other day, because I do work with a number of seniors, and I typically oftentimes have to go to nursing homes.
Oh,
So I should be fully vaccinated by the end of the month.
good. Glad to hear
So
that.
then hopefully people will come into my office instead of this odd thing here. So just a little handout. It's just a quick overview, but so initially the way to hold title, if you're a single individual, you would say a single man, a single woman. And the reason we do that is so that it's very clear on title, because they'll want to know how are you holding it. Because there is a married man or a married woman owning this as a separate property. So title is the one we want to please. I mean, the title company, when we're taking title, because they're going to want to say California is a community property state. If you are married, they're going to want to take an extra step and say, this is your separate property. So I need to do a quick claim deed and have your spouse acknowledge that, yes, I have no interest in this property. So in order to, in order to satisfy title, which is what you want to do, think about people that are buying it as an individual and not putting their spouse on. In California, we do recognize same-sex marriages, but we also have registered domestic partners that are treated just like married people. So if there are registered domestic partners, a lot of times they're seniors that maybe don't want to get married because they're collecting on their former spouse's Social Security. Sometimes they'll be a registered domestic partner, but they'll have to do the same thing. If this is separate property, they'll want the spouse to sign off. So that's separate. I think she has to go out. I apologize. Can you give me 1 second, please?
Yeah, I'll take it from here.
Yeah, go ahead.
Okay. All right, guys. All right. So while she's taking care of her dog, in my estimation, she said 50%, over 50. I would say it's closer to 100, because we sell a lot of property. I see how people hold title. I actually, I was just talking to a real estate agent about this the other day. She wants to start an LLC to hold real estate, and Miranda could touch more on it, but I own a lot of real estate and I don't have an LLC, right? But there's pros and cons to everything. We could talk a little bit more about that, but go ahead. You could take it over from here.
Okay. All right. She'll probably bark again, but I left the door open. Okay. So that's single person owning, or owning it with one name. The tricky part comes when you have multiple owners, either husband and wife or siblings, or investment, people going in together in an investment. So in California, I'm gonna let somebody in here. In California, we are community property, and what that means is anything that you earn and acquire from your earnings during the marriage belongs equally to your spouse.
During the marriage.
During the marriage, correct. So if you are married to someone that doesn't work, and these laws were set up when women often stayed at home and raised the children and the men went to work, the man couldn't keep all the money. It was half the wife's as well. And nowadays, a lot of times it's reversed, and the wife is making more of the money and the husband's doing something else. But that's the bottom line. There's ways to get around that. There's legal maneuverings you can do, but we are a community property state. So if you take title and you say husband and wife is community property, that's proper. And what it does is it gives the other surviving spouse on the death of the first spouse the opportunity to give their half to someone else. So a lot of times this isn't good, because the surviving spouse doesn't want to have to go through any legal maneuverings. We don't want to go through probate. We just want the survivor to be able to do what they want with the full property rather than just half. So there's some legal maneuverings that we do. But it's just very important to be aware that California is community property, but we still need the court. And one of the ways you get around that is community property with a right of survivorship. And that's half and half for each of the spouses. You have to be married for community property. And then automatically on the death of the first spouse, it goes to the second spouse. But it doesn't take care of anything beyond the spouses. This is only between spouses. It's not parent-child. It's not sibling. It's just husband and wife.
So like in the first example, community property, that's like, well, let me start with the second example, community property right to survivorship. So that's probably like somebody, a couple that they're getting married for the first time. They don't have any children from prior marriages. And they're just like, well, yeah, if I pass away, you get the rest of the property, or if you pass away, I get the rest because, we're married. So the first one, community property, almost sounds like a couple who maybe have, kids from prior marriages, or like, I don't know, really deep family ties where they're just like, hey, I want to be able to leave my part to my family or to something like that. Is that accurate? Or
that's very accurate. Yeah. And sometimes it's maybe the parents of the couple put the money in, and you want, hey, if something happens to you, your half comes back to us because we put the down payment or whatever.
That makes sense.
But it's not always a good thing, because again, that second half, or the first to die, that may need to go through the probate court. And even if there are no children, there's no other family members, the surviving spouse has to file what's called a spousal property petition. It's not a probate petition, but it's something.
So basically they need somebody else's permission. If their spouse dies, they need somebody else's permission, which is like the state,
to transfer the one half to them.
That's crazy.
Yeah. So we don't use that. But the reason we like community property is because we get a step up in basis, what we're talking about with the capital gains. So their cost basis is what they purchased it for. And if the surviving spouse wanted to sell, they wouldn't have a gain on the property if they sell and move to a different place with community property.
Yeah, and we could talk about gain and all that like towards the end, I think, because that's going to be a little bit more advanced. But we
don't even have to talk about that. You could get a CPA on here and they'll be better. But anytime you're dealing with sales of large assets, you do have to consider tax consequences.
Yes, okay. I agree, 100%.
Okay, so the third way is joint tenancy, and I'm going to say probably the majority of the deeds that I see are husband and wife as joint tenants, and that is one of them dies and it automatically goes to the other one. And again, sometimes you don't want that because you have children of a previous marriage that you want your half to go to, and it doesn't deal with what happens if both of them pass away. You still have a probate issue.
Yeah, when you say automatically goes, does that mean like it avoids probate?
Yeah.
Oh, okay.
Yeah, between two owners. And this one does not have to be husband and wife. It can be siblings. It can be joint investors going in to buy a property. But joint tenancy, it's by operation of law. You just file an affidavit of death of the joint tenant, and the surviving tenant is the owner.
Okay, cool.
And the thing about joint tenancy, you have to acquire the title at the same time. It's not something you can add to. So when we do a deed, maybe somebody wants to change from sole and separate property to joint tenancy, they have to deed it back to themselves again so that both names go on at the same time. So.
Got it.
And then tenancy in common. 2 or more people don't have to be married. They can add at any time. And this is the fallback position. If you just put Mary and John Doe without any qualification, without saying husband and wife, without saying tenants or without saying joint tenancy, If there's nothing listed, it's tenants in common, and each individual, their share is going to go through a probate process to transfer to somebody else. There's no automatic transferring. So people get surprised a lot of times. I have individuals coming into my office saying, you know, so-and-so died 20 years ago and we've been living here and now we want to sell, but we realize we don't own it because this deceased person's name is still on here because joint tenancy, it wasn't joint tenancy, it wasn't automatic. It has to go through probate.
Yeah, I remember a deal like that. It was pretty gnarly. I'm trying to remember the details, but yeah, go ahead.
Yeah, and a lot of times when people try to do their own deeds, they end up having a tenancy in common. So I guess one of the horror stories that I was thinking of is I had a client who came to me and we talked about estate planning and why she wanted to avoid the probate process and also provide for her son upon her passing. And I quoted her price and she got to be where she is, I guess, by not spending any money. So instead, she put her son's name on her home. I think there were 2 homes, bank accounts, investments, and he was in a car accident and caused 2 fatalities. So your car insurance is only, maybe $50,000 or whatever. A lawsuit ensued, and I think it was like almost $4 million. The son was definitely at fault, and woman lost her real property. She lost everything except for her retirement because you can't add someone on that. So I tell people, even if you think your son is upstanding, my son's in the Coast Guard and I'm proud of him or whatever, I would never put him on any title. You only want your creditors to be able to touch your assets. So yeah, that tenants in common, people think it's a good deal, but it's really not.
And I think your example went over a lot of people's heads because a lot of us, we don't know what estate planning is, right? And really how important it is. And even myself, for years I created my own trust, since 2005, I think. And I thought I could do it, but there's all these things that I didn't even take into consideration as a real estate broker. And there's a lot of there's a lot of ways that I could have really got in trouble through the lack of insurance, proper insurance, and just protecting my assets. And if you let somebody, you let somebody borrow your car and they get in an accident, I mean,
oh yeah, there's a lot of stuff. I mean, somebody's name on your assets creates a problem.
Or
so
even
then
insurance.
Yeah. Yeah.
Insurance. I mean, there's all these things we don't even know about. We don't know about. You do because you live with that stuff.
So then the other ways, and then we'll talk more about that, is putting properties into a corporation, a partnership, or an LLC. Sometimes I will do that with my clients that have several different properties, multi-unit properties. We'll call it, like the person who owns my building I'm at 3322 Sweetwater Springs. So he's created an LLC, 3322 SS LLC. That's who I pay my rent to every month. But he's got several other buildings and he's set up several different LLCs so that the liability, this is a liability issue. If something happens in our building, the insurance only deals with that building. He's not drawing from his other assets. He also has us indemnify him with our insurance, but it's self-contained. The building is self-contained. And I have clients who come in to see me and we do an LLC for an apartment building. So it's separate from their personal residence or other property that they might have, and it's separate from their other assets. So it's a protectionary thing where you have to have a legitimate business. Sometimes people go, oh, I like that protection of liability, I'm going to put my house in there. Well, this house, it's not making any money. It's not a true business. But if you have rental properties, it may be something that's appropriate. And then in the operating agreement of your LLC, you can say kind of what happens to dissolve the LLC. So if you die, who the corporation would then transfer to. So you have succession planning within the LLC. And if it stays in the LLC, it's not going to get, well, it still will get reassessed. I mean, that Prop 19, you probably have had a lot of discussions about that now. I've attended some of those things. So anyway, you want to get it, it may be reassessed when you place a asset into an LLC if you change the percentage of ownership. So if you go in and you say, I'm going to give this to my kids and I'm not going to give it to them outright, it's going to be in an LLC. If you include them as owners of the limited liability company, that's what it stands for, then there will maybe a reassessment for some of that rental property. So you got to be careful.
That's interesting, because right now, again, you touched on a bunch of points that we wouldn't think about. There's a lot of people that would just say, hey, let's create an LLC, let's transfer the properties into an LLC because I heard it's a great thing. And all of a sudden there's a law they don't know about, Prop 19. And that would cost them big time, so, and that's brand new. So I think I think everyone on here, including realtors, should hire a professional whenever a professional is needed. Like, something's wrong with my car, I don't go underneath the hood and try to figure it out. I don't do that. But I did with stuff like this, but I realized I can't even do that with stuff like this. I got to hire a professional like you to take care of it. So
right, like I would never sell my house without a realtor. So it's kind of the same thing. You have to rely on other people's training and expertise. Right. So the last thing, and this is kind of where we're leading and why Voltaire was saying this is really important, that people don't know why they should hold title in a trust. The trust has the benefit of avoiding probate. It has the benefit of transferring on death to whomever you want. Doesn't have to be a spouse, doesn't have to be a co-owner. No one else's name gets on your property. It's your trust, and it's, if you have your house, you're putting it in there. And you can, the only thing that's public about it is the title. Like mine is Miranda Frank Separate Property Trust, and all my properties are in there. But if I want to make changes to who gets what or how things are handled, I change my trust, and title can remain. I mean, it's been probably about 20 years since I set up the trust. So anytime I were to acquire new property or sell property, I'm my own trustee. And on my death, I have a succession plan that's not public, and it will never be public. The only thing that's public is the deed, which says it's in a trust. So it creates a lot of flexibility. I have clients that have multiple children that maybe this year they're getting along great with their daughter, and the next year she marries someone who's horrible and has control over her. So the client realizes, well, my daughter can't be my trustee. It's going to be my son now. And nothing has to happen with title. It just happens with doing an amendment to the trust. So it's really
I think you struck a lot of nerves. I think you struck a lot of nerves with that example, because I see that all the time, especially when, when the parents are helping out with the down payment or whatever. And yeah, so go ahead. Yeah, that's funny. You said.
Yeah, and even in the trust, I mean, if there are some things that have to be paid back to the parents, and let's face it, I mean, the price of real property is, it's going through the roof. Yeah. So a lot of people do need the assistance and guidance and financial help from other family members. So that if it's held in the trust, maybe the family member, instead of having like a deed of trust recorded against the property, we can have, some language within the trust that says if this homeowner dies, that the parent is paid back whatever the unpaid balance of the loan is. So it's not, again, it could be a private, not recorded, but then there's terms and conditions that the trust can handle.
Got it. Okay.
So, it is important that people look at their estate, and purchasing a home is probably the most expensive asset that most people own. Whether it's a home, whether it's an investment property, It's really important that title be held in the right way. And maybe there is before it goes into the trust, it would be my property, a married woman as her sole and separate property, and then transferred into a trust. So there's no chance. I mean, I'm single now, but if it were before my divorce, I would definitely have wanted to have that sole and separate language in there, and then transfer it into the trust, so that there's the chain of title would show that the spouse's name never got on the asset.
Oh, yeah. So that's interesting. And you're telling me, I mean, I'm listening to you, and I mean, I've been in this 18 years, and I've read a lot of deeds and gone through this a lot, and even I'm catching little nuggets. So I know people that are watching, it's going over their head, like all these little, dimes that you're dropping, really, and but I get it. So I guess, for everyone that isn't in real estate 24/7 like myself, um, I'll let Miranda go into the other benefits of the trust, but I didn't know how in depth just estate planning was. I didn't know there's like all these other things, power of attorney, medical directives, just making sure that, you're properly insured, you know, and these are all like things that you could advise on, that you could say, hey, look, talk to your insurance guy. This is the type of, you know, let me look at your real estate. Is your real estate property insured? Let me look at your assets. Are they properly insured? Whether through insurance or through an LLC or through a trust or through whatever other entity, right? So tell us a little bit about exactly, I just kind of mentioned a few things, but what did I miss there? Like what is estate planning, by the way? And I know we're not talking about title right now because you're going to talk about that, but what is estate planning? What does it all like include?
Okay. Well, estate planning is planning for continued management of your affairs in the event that you either become incapacitated or obviously on death. We have the population is growing longer and longer in years. And so there are incidences of a lot more incidences of different family members having to take over for their mothers and fathers and grandparents as they age. And the estate plan is a vehicle that allows, before they get to the incapacitated state, to say, this is what I want. If I can't handle my affairs, I need to nominate someone who, number one, is a power of attorney. And the power of attorney isn't just banking, it is talking to the insurance company, talking to the pension provider, hiring people to do maintenance in the, you got the yard maintenance, you got the pool maintenance, all these things that you take for granted. If you can't do that, when you become incapacitated, you're subject to being unduly influenced, taken advantage of, or just not taken care of. So the power of attorney is one that comes into place. I think everybody should have one, even if you don't even have any assets, just so that you have somebody that you love and they love you and they're going to do the right thing for you. So that's one document. The other document is an advanced healthcare directive. And again, as we age, but not even age, you could have an accident or something happen to you where you're not fully able to express what your desires are in terms of taking care of your health needs. So again, sometimes we have dysfunctional families, and maybe you've got someone that really isn't loving and caring, but they might be really good for handling the finances. But when it comes down to your health needs and making those life and death decisions, they're not the best ones. So you want to be able to, when you're fully capacitated, make that choice. And I always have my clients do a number one choice and a number two. And it isn't always the kids. It could be like your best friend or your sister or your mother. Typically we go down a generation because, like I said, this is long-term planning, so it starts now and as you get older. So you wouldn't want to go up a generation. You would either have somebody in your same generation or go down.
You want somebody that doesn't give up easily, right? So,
Yeah, well, unless that's what your wishes are. It's like,
yeah.
so,
So I don't want to. I don't want to move off the topic because I want you to finish kind of going over all the documents included, like in a estate plan.
okay. Okay.
But something
Oh,
popped in my head. I get the question a lot from people that own real estate and want to transfer it to their kid's name or to someone else's name because they get some type of medical benefit or social security, or I don't even know what type of benefits they get, where they're just like, hey, I own real estate, and after a certain amount of assets, I don't qualify for those benefits I'm getting, so I'm going to transfer the property to somebody else's name. What is that about? How does that work? I mean,
you know what? I don't do a lot of it's Medi-Cal planning, and that is when we all work, and when we pay taxes, we pay into Medicare, which at 65 you're able to draw on that. If you get Social Security, you also get the Medicare. But if you have, I think it's like $2,000 in assets or less, you can qualify to get Medi-Cal. It's called Medicaid in other states. And it's not the best health insurance, but it's a supplemental health insurance that if you don't have assets. And so a lot of times people will try to reorganize their estate so that they don't have assets in their name to qualify. And I think there's a place for that if there is truly like a terminal illness and you're going to need extensive medical care. But you do qualify even if you own a house and if you own a car, because they say if you have to get to medical appointments, you need to have a car and you're allowed to have a house. Now, at the end of your life, when you pass away, the state of California, which funds the Medi-Cal, will present your estate with a bill to be paid back. There's a loophole. If your house and your assets are in your trust, there's no estate, there's no probate estate. So the state of California, I think they're probably going to close that loophole, but that's been for the last 2 years. They specifically do not go after assets in a trust.
wow.
So even a basic trust, just transferring your house, you would still qualify for Medi-Cal because you're allowed to have a house. And then you would, upon death, they won't make the claim.
Wow, that's interesting. Okay, cool. So that's what that's about. And I've seen that happen all the time. People just transferring it to other people's names.
I wouldn't put it in another person. I would put it in the trust because you're allowed to have the house and the investment stuff. If you have good investment property, you know what? You got an income stream. You should be paying your own medical bills. I'm just, there's an element of fraud in there when you start to move around. That was my cat that just walked by. So
you got like a little zoo over there and just walking by.
I do. I'm gonna shut the door now that all the animals are in. Just a minute.
all right, no worries. That's all pretty interesting, guys. I think. By the way, you can ask questions at any time. Feel free to throw it in the chat or mute yourselves to ask questions about estate planning, about how to hold title, about specific situations. Because again, I started off this by sharing a story of a friend who, unfortunately, the way I see it, lost a lot of money just by not planning ahead of time. Okay, so going back into, by the way, ask questions anytime in the chat or just unmute yourself. So Miranda, so going back, so you talked about the power of attorney, the advanced medical directive, that's part of estate planning. What else is?
Yeah, the main document that we do is the trust. And a trust is basically, there's 4 elements. A trust there has to be an asset. So let's say the real property. There has to be a grantor or trustor, the person that owns the property, transfers it to a trustee. And then there has to be a beneficiary. Well, the term living trust, which most people hear about, and that's your basic estate plan, is a living trust. So in my case, I'm the settlor, trustor, grantor. I grant my real property to the trustee, and I'm wearing that hat too. I am my own trustee. And then the beneficiary during my life is me. There just has to be a contingent beneficiary upon my passing. So it's really simple. You know, the language that we use in the trust is all of the powers that you have owning real property outside of the trust, you'll still have it inside the trust. So if you own rental property, you'll still be able to manage and rent that. You can refinance, you can buy, you can sell. You're just going to sign your name as trustee. So people come in and they say, well, I don't know how long we're going to hold on to this property. Put it in the trust, it won't matter, you know, because a lot of times people forget. And then if it's outside of the trust and they pass, a lot of times we end up going through the probate process. And, you know, if you've never been through the probate process, I do a lot of that too. It's just very expensive and it's public. So one of the good things about a trust is it keeps it all in the family. And sometimes people are very particular about what they want in the, you know, my kid doesn't get this until he's 35, and then he'll get a portion, and then at 40, and then at 45, and then at 15, we're thinking, okay, if he's 15, he can't handle his money. I don't know, you know, but there are clients who want a very specific plan like that. And a probate is just 100% distributes outright. So.
Yeah, that's I think a huge benefit to this is just, you know, the privacy of having a trust, you know, people not knowing what's inside a trust, you know, who you're leaving stuff to. Tell us, just curious, what's the most shocking, you know, situation you've been in where, you know, someone passes away and you have to administer the trust and basically let the beneficiaries know, hey, you know, so and so your grandpa or your uncle or whoever left you this and that, and didn't leave you nothing. Like, have you been in those rooms where you like have to give like the news?
I do. We actually I'm drafting one now. The couple has 3 children, and their trust has 1/3 each. And they came in and they said, you know, they're having me change it so that only one son gets a bulk of it. And then they name, I think, 3 charities. And it's because they watched their 3 children receive an inheritance from the grandparents and what they did with it. 2 of them squandered it away, and started asking about the parents, what are you doing with your money and all this? And then the 3rd one invested it and did the right thing. And so we're changing it all. And
Wow.
we're actually revoking the old trust because the other 2 children have copies of them. And I tell people, you don't have to give the copy of the trust to anyone. You just need to let them know where it is. And yeah, so the one kid is going to end up, you know, I don't know exactly how large the estate is, but there's a house and a rental and, you know, some investments. So
Wow.
it's really not nothing. And then they're giving to their church and the rescue mission. And their veterinarian gets a chunk of it.
Oh, shoot.
So I like that. I mean, I got lots of pets. So that one. And then I've had one where 4 kids, they come in and it doesn't go to any of the 4 kids. It's just a college fund for the grandkids.
Oh, shoot.
So, and 2 of the grandkids had already gone through college, and the siblings with the kids that were younger were like, okay, cool. So there was no benefit for the oldest child whose children had already gone through college.
Wow. So that was well, I'm assuming they're shocked, right? Were they like
They were completely shocked. They thought it was going to be a 4-way split because that's what normally families do. So again, I suggest people revisit their trust. You may have a trust right now. I do a free half-hour consultation when people need, you know, and I tell them, sometimes people sign their documents and then walk away and they don't remember what they have. So I can look through and say, okay, this is what it says. And they might be in shock because they don't remember, 20 years ago what they wrote down.
Yeah, and I think that college story kind of tells it all because
Yeah, all the kids were little when they
yeah,
first signed it. So
yeah, the kids were babies or whatever, and they're like, okay, we're gonna put them through college, but they just lived longer than they probably thought, and they just never revisited their trust.
yeah.
What about some of your more juicier stories with inheritances?
Oh gosh. Well, let's see. I've got
Baby mama. You want to hear the baby mama drama?
no, I've got one where um the dad had a trust drafted, and then he made his own changes,
Mm,
which didn't make a lot of sense, but basically he had disinherited one of the children. And then when he died, the other two children were, I don't want to say druggies, but I think they kind of were. It turned out both the brother and sister passed away. And so the one daughter that was disinherited was trying to make a claim, but the bulk of the estate went to the dad's longtime mistress because the mom had previously died. So the
wow.
whole family was wiped out basically, and it's this woman and it's a large estate. So that was wild. I had one up in Rancho Penasquitos. That was it, Rancho? I don't know. They had a ranch with some horses, and it was the mom died first. The dad left everything to the horse trainer, the hot little horse trainer. So
Wow. It pays to train horses and it pays to be hot, I guess. Um, okay, cool. Yeah, and again, with a trust, you could do all these things. You could leave it to whomever you want, to the responsible kid, to a longtime friend or someone who's taking care of you. Um, where if you think about it, if it was just under your name or whatever, you pass away, it goes through the probate. State of California, just so everybody knows, state of California gets involved in a probate. So when you pass away, the way most of you are holding title to your property, you pass away, state of California, grabs the property, holds on to it, and says, we're going to find out who really owns this property. So if you had a kid who isn't the most responsible kid, or a family member who you don't really want to have the property, they're probably going to get it if they're the next to kin or whatever, compared to your longtime friend who was there for years taking care of you while you're sick and your kids wouldn't visit you or whatever. I mean, you can leave it to whoever you want, and no one has to know until you pass. So I think that those are some pretty cool benefits that I think people should know. But cool. Any final words? By the way, anybody on that has a question about holding title or the type of title that you're currently in, because all these things that Miranda pointed out, they're pretty very useful information for sure. No? Okay. Any closing thoughts, Miranda?
well,
I know you said you would give some free consultations.
yeah. I mean, you could call me. I guess, did you send out my info or?
Yeah. If you guys have what we'll do is we have you guys' email. We'll send everyone's Miranda's information, and we actually do have a couple questions. Sorry, I wasn't paying attention, and my
Okay.
partner over here wasn't paying attention either. Okay, first question. How is that different than community property with rights to survivorship for a married couple? I'm assuming.
How is it trust different, or how's joint tenancy different?
Good question. We'll follow up on that. Don, joint tenancy. How is joint tenancy different than community property with rights to survivorship for a married couple?
It basically acts the same way. But joint tenancy can be with multiple, you could have 10 people all taking title at the same time as joint tenancy. They don't have to be married. They have to have the equal share, equal time. It's the equal one. but community property with rights of survivorship is only between I was going to say husband and wife, but it could be a same-sex married couple in California, or a registered domestic partner, which is treated just like a married couple.
Okay, and then now, did you mention before that with community property, oh, with right to survivorship, okay, so it's treated just as joint tenancy, right? So basically,
Yeah.
you don't have to go through probate or anything like that, only.
Yeah, but with regular community property, the deceased spouse's half of the community can either a spousal property petition through the court, or they can have their own will, or you can even have your half of the community severed and put into your trust.
Got it.
So, yeah.
Okay, cool. I hope that answers your question, Don. Lee J asks, can we expand on the process of a quit claim to title? And then also, in your experience, is probate ever a good thing? What is the
Okay.
typical waterfall of an estate?
I think the quit claim for title, I was saying if an individual is married and they take property, a married man as his sole and separate property, the title company, to give clean title, typically wants the wife to do a quit claim saying, I quit claim any interest that I may have in this property to my husband. And that's a clean way, so we don't even have to look at the community property statutes and see what applies. So the question is, probate ever a good thing? I'm going to say yes. If we have families that do not get along at all, and we know we're going to end up with a trust through the court system, why not have a probate? We get there, the court's kind of controlling the process from start to finish. It's the same thing. As a trust administration, we have to make sure all the decedent's debts are paid, whatever outstanding bills. We have to marshal all the assets. We have to figure out who the beneficiaries are. And then we distribute at the end after the court has verified that everything was done correctly. But if we got a family feud going in, and then I do have clients that maybe their level of understanding isn't as, they don't understand a trust, but the level of understanding for a will is you just have to know basically what your assets are and who you want your beneficiaries to be. That's a really basic standard. A trust is actually like a contractual, the document is a contract basically, and it takes a higher level of understanding. So if I have someone who maybe has early stages of dementia, but there's no undue influence, they just don't have a good, clear understanding, we'll do a simple will, and that will go to probate. And that's the fourth document actually on the estate plan. We always do a will too, not creating a new distribution, but basically saying those things that don't have title, we transfer on the death of the decedent, we transfer everything according to the terms of the trust. So it's not a new scheme, but it's just like to take care of the whole picture. And it's not something that actually would go into a probate necessarily, unless there's big ticket items that are outside of the trust.
Right. So the will is the one that you didn't cover. And the will basically covers. So a lot of people, I hear that all the time. Oh, I have a will. I don't need a trust. Well, that's not.
A will goes to probate. And that's okay. I mean, like in that instance where if we think that probate's a good thing, sometimes I have people that are, they have a lot of real property, but no cash. And they say, I don't want to pay, my trusts are about $2,500, $3,000. They're on a fixed income and literally all they have is real property. So the kids are going to pay at the end of the day. Sometimes I say, well, maybe if you want to ask your children, explain why you can't pay that, because they're going to pay a lot more at the end. So that's the other thing. I make a lot more doing a probate than I do administering a trust. So just,
yeah,
it's statutory.
I bet you do. Yeah.
Yes,
There's probably a lot more gray hairs though, right?
Yeah.
All right. So hope that answered your question, EJ, and then hopefully it answered your question about the process, expand on the process of a quit claim to title. And again, Miranda just said that it's somebody quit claiming all their rights and interest in a property And that way you're able to refinance or just own it outright. So that a lot of title companies ask for that quick claim from the spouse or from somebody who previously had interest in the property. But it's
Yeah,
a simple,
they want to make it clean.
they want to clean. It's as simple as signing a deed in front of a notary, right?
Correct.
All right, cool. Then Claudia says, add me to your trust. I don't know. Yeah, how do you know you aren't in my trust already? Yeah, you got to think positively.
No, but I have a question.
Sure.
So for copies, is it just better to have one copy? Or
I think it's
know you
one,
mentioned-
just your original copy. When I do a trust, I have the clients, I have my working document, and then I have their signatures, and it's all in the cloud, so we can recreate one for them. But because so many people, I say revisit it, take it out, look at it, and like every 5 years, because there's a list of assets that's probably changed. Maybe the people in there might have changed. But if you have multiple copies, that creates a problem at the end of the day, because which copy is, the valid one.
So just keep one and then just keep making changes to it over time.
Yeah, we do amendments. Don't write on your documents.
Okay, cool.
Yep.
Next one. What type of title do you suggest for a mother and daughter purchasing a condo together?
I would say in a trust. I would say a joint trust. And if the daughter has children that she wants to leave her interest in, she can do it that way. Or if the mother wants to leave it to somebody else, maybe there's multiple children, the trust would take care of any equitable distribution at the end of the life of one or the other.
Okay, cool. Yeah, so mother and daughter purchasing together, a trust. Good question there. All right, I think that's about it. Unless anybody else
Another
has.
question, Voltaire.
Go ahead, Samantha.
I see this on TV a lot, that they're saying that somebody was added onto the title, or they try to advertise like protect title for this low monthly fee. How true is that? Can people be automatically added, or do you know what I'm talking about?
Yeah, they try to sell you something like, we'll check your title for you. I think that's ridiculous. I've never ever seen that happen. And I have an account with First American. If somebody called me, I could check their title for them. It's just click into there and do it. And I wanted to say something. I know there's a number of realtors on here. When it comes time, somebody's died and they have to sell the property, check title right away. That's really important, because you need to know, am I dealing with the right person? Do I need a probate? What's going on with this? Because I get calls where they're already almost in escrow. They've had a listing agent, and then it turns out it's still in the decedent's name, and we do need a probate. You can't just sell somebody's property. Even if you're the sole beneficiary, there has to be a process to get the title out of the decedent's name. Or it's in a trust, and you read the fine print, and there's 2 trustees, and you've dealt only with one the whole time. I've got some litigation now where the siblings, I hate naming 2 people at the same time, but once they're not getting along, and the realtors got them to sign up all these things, and I think, trying to get into escrow. And so first thing you do, if, this is my mom's house, she's died, pull title.
That's a good that's some good suggestion there. Saves a lot of time. I've gone through that several times in my career, and
Yeah. Yeah, because then it's an emergency and I'm scrambling. I can get a special administration, but one of our judges says, well, just because it's your emergency, no, the beneficiaries aren't going to be harmed, and you can go a couple months without paying the mortgage or whatever. Or the reverse mortgage situation, that's a time sensitive. If you pull title and find out that's the kind of loan on it, we need to act immediately with that.
Cool. Yeah, thanks for all the info. We're going to share your information with everyone. That way, if we ever have any title questions,
estate planning,
they
or
plan-
dead people in general, just give me a call. We handle it all.
Someone dies, call Miranda. She got you. Okay, cool. Well, thanks a lot for jumping on. And we appreciate you. Everyone, have a great night. It's Tuesday. Sounds like maybe order some pizza and just like watch a show. That's what it feels like tonight. So catch you guys later. Thanks a lot.
Okay, bye.
Thank you all. Have a good night.
Good night. Good night.
Bye-bye.
Later, Don. Later, Lee.
Armando.
Bye. He was waiting to the end. He's like, okay, I heard everybody's out.
Have a good night.
All right, later. Later, Max. See ya. All right.